5th will be Peter Gichobi Kamoto. 6th additional will be Grace Modoni Mwangi. Clement Muchiri Moyoki will be the 6th, and the 7th will be Edwin Monene Kariuki. The respondents will appear as follows. First, to the 5th respondents, as they appear in E565 of 2024, that is the Speaker of the National Assembly as the first respondent, National Assembly of Kenya as the second, Speaker of the Senate will be the third, Senate of Kenya will be the fourth, and the Honorable AG will be the 5th. HT William Ruto, the President of the Republic of Kenya, will appear as the 6th respondent. And the interested parties, the first interested party will be LSK, as first interested party. And there is a second one. The second one will be Professor Kithure Kindiki as the second interested party. Unless there's a party which is left out.
Yes, my lord, with your
I should have for the payment.
Is there anybody who has been left out on the quorum to amend the constitutional conditions? Yes.
I was left out in the morning with petition E013 of 2024. I had not been notified, and therefore I learned of these proceedings on the Nation TV, and I decided to come. So therefore, here we from Kirinyaga, because Judge Richard Moore was very clear that we are going to be notified once the file is forwarded before the Chief Justice. There was no communication, so we were left stranded. What is happening? And our petition is being mentioned here today, and therefore we have had to rush very fast so that I can make it in the second session, the upcoming session. Therefore, I did.
Which petition?
The consolidated petition.
Which petition is that?
Petition E13 and E14, Kargoya.
Yes, it was consolidated, and we were told that we are going to be notified. However, we were not notified. I just learned of it today on the TV at 11. So we had to rush really fast from Kargoya so that we can understand what is happening and perhaps clarification purposes.
Is there anybody who has been left out of the...
My lord, with your permission,
yes.
Just to draw to the court's attention, there is an application lodged on behalf of an interested party
Intended interested party or interested party?
It's an intended. He has not been joined as yet.
And my lord, on the parties,
Yes.
in this petition, I'm assuming it's one of those that you have mentioned, 528 of 2024.
No, it's not.
We have not mentioned that petition, and on that score, let me say this, that in the morning session, there were parties who had mentioned different petitions which were not before us. I think we should be very clear that we can only deal with matters which are before us. Should there arise a need for us to mention any matter which is not before us and which has been placed before us, we shall make that communication. So I think we need to be very clear that our jurisdiction is prescribed to particular files. Thank you very much.
My lords, your ladyship, permit me to request that in E565, in which the Deputy President is a petition, and E015, in which the Deputy President is a first interested party, let the record of this honorable court show that we were not given an opportunity to be heard on the issue of consolidation. And the record shows the court has acted of its own volition in the normal practice, even under the Matunga rules, is to accord parties to state their views on proposed consolidation. This cultural violation, we were not asked to do. Thank
Your Lordship, we have had the order that has been granted by the court, consolidating the matters and creating another lead file. And that creates the problem you are trying to address in the morning, Your Lordships. That now this bench has created 2 lead files. We have 6 files that are before you, Your Lordships, with the lead file being E522. Which files are not before you? We have now created another lead file, E565. Your Lordship, those are some of the issues we were trying to raise in the morning. That if those other files were before you, this confusion would not be rising.
Mr. Ndegwa, there's absolutely no confusion in these matters. Let us not bring confusions where there's none. I think in terms of consolidation, we have cited the rule under which we have acted, Rule 17 for avoidance of doubt of the Mutunga rules. I think we need to move forward.
Yeah, and my lords, on behalf of the respondents, we confirm that we are ready to move forward. I think too much time has already been taken on issues that are not very substantive. Save, we would like to make 2 proposals. First, we would like, my lord, having read what has been filed by our colleagues this afternoon, we would like to propose that their application for recusal and this application questioning how the panel was put together should be had together. For the very simple reason that they rely on the same set of arguments and facts. And I draw your attention to paragraph 5. They say that the impartiality of this court, the one we are before, has been questioned. And at the end of their prayers, they say that it is therefore in the interest of justice that this honorable court recuse itself. It would be gravely injurious to the respondents if they were allowed to prosecute this application, take one bite at attacking the court,
And however the court rules, bring the other application for recusal and take a second bite. We would like to argue both of them together. Secondly, we would like an allocation of time, because it is quite clear to us that in the absence of directions allocating time, we are going to have another long afternoon of long, winded speeches that do not address the specific issues. We are willing to say in advance that whatever time you give us, if you give 10 minutes each, we shall accept. If you give 15 minutes each, we will accept.
Have you cited the applications? Have you cited the applications? Have you considered the applications? It's still okay. 6.1. Professor Githu, which applications have been filed? How many applications?
The one you directed, my lord, in the morning.
Yes.
Yes. But it is in that application that has been filed by Jindo Matiba and company advocates. That is the application that seeks, on the one hand, that questions how this bench was appointed, and on the second hand, it requires the recusal of this bench.
So for avoidance of doubt, it is one application?
It is one application.
There are 3 applications.
But there is an earlier application for recusal. And that's why I'm saying we probably can hear both of them together.
Yes?
I'm sorry, my lord, my lordships and my lady, I just wanted to remind the court of Article 159 of the Constitution. In exercising judicial authority, the courts and tribunals shall be guided by the following principles. And 159(2)b, justice shall not be delayed. So I'm requesting my lordships and my lady to kind of refer to that provisions and let us move forward. Thank you.
My lord, let it come on record that this is the first time in which, on a matter of extreme national importance, we've been given 1 hour to be able to do an application, serve it, and come back to court. We have tried to do the best that we could in terms of complying with those directions. Of course, one of the issues that we could not be able to do is that the written application could not be able to do full justice to the instructions that we've been given and to our case. And therefore, my lord, when Professor Gedu Muigai stands senior counsel to say that we need to be gagged on the issue of time, we protest. We shall require sufficient time. This sufficient time is not forever. This sufficient time, at least for purposes of the 3 presenting the that applications, is 1 hour. It is the least that people deserve in an application of this nature. Second issue, my lord, is the issues of consolidations. Those issues of consolidation are as different as UDA can be from Jubilee. And the issue is, for purposes of the difference, the application under Article 165, and we did not hear you talk about the inclusions, because we've had to include. Their earlier complaint in the morning...
I'm sorry to say this.
I have...
Yes, I want to interject. If my learned friend is appealing against your orders, then there is the right forum.
There is no order.
My lords and my lady take charge.
There is no... I'm responding to what has happened. Let us be fair to each other. And my lord, what I'm saying is this, that for purposes of those applications, the application under Article 165, because in the morning when we raised the issue orally, the questions that was raised, you are raising issues against the Deputy Chief Justice, who is not a party. She is a party now, and we have served her. We too there, application on the issues of the constitutional violations regarding the empanelment of this bench. We shall need the court's directions on that issue. And we've gone through the authorities within the short period that we were here. So we are standing on solid grounds. We just need sufficient time to do our business. Issue number 2, my Lord, if that applications were to succeed, then it would effectively mean, as my learned colleague Mr. Ngoya had indicated, then the issue of recusal of your lordships becomes academic. But if your lordships were to hold that all these serious injustices that the petitioners allege were committed by the Deputy Chief Justice are okay, then we shall now address you, the issues that concerns you. And I need to add, on the issues of authorities, because now we've been told different instructions. When we came here, we thought that while we were proceeding and taking directions, prepare the team in the office, let them prepare authorities to argue on the issue of recusal. When we were given 1 hour, we told them, oh, stop on the issues of recusal, now we are dealing with another thing. So, my Lord, we cannot be able to argue, if it is today, we cannot be able to argue, as expected by our client, on the question of recusal. And there is no similarity of issues. Therefore, my Lord, I urge you that let us adopt fair procedure. This fair procedure has always been there. There are 2 applications.
Where are they? There are 3 applications.
At least I know, Deborah will mention one.
Yeah.
We are actually bringing them even, one of them in number 015 is an application dated, I believe, yesterday, 21st of October. There is another one. The other one, Deborah. Yes, my Lord.
E0. We'll deal with the application before us.
My Lord, may it please you.
The application for empanelment is mentioned. Where's the application? Where's the application? Empanelment.
Yes.
Perhaps, my Lord, perhaps before you give the directions, with my learned friend, Ms. Kimotho, she's informing me that she was not aware of directions in the morning, that applications be filed and we come back before you. And now her petition has been integrated in the consolidated petition. That is petition number E013. Therefore, she's not been able to file an application either for recusal or for challenging the empanelment. She was just requesting if she can be served with those applications and the responses, and she be given time, 1 hour just like the others, to file her similar application if she so wishes. Because now she's participating in a proceeding, she did not directions.
Council, listen to this and listen to this very carefully. All of us acknowledge the momentous import of the proceedings before us. And all of us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will not be taken round in circles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue our matters. We want everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the cause in cycle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with is an application dated 22nd of October 2024 by Jindo Matiba and Company Advocates. It seeks orders under Rule 3 of the Constitution we are dealing with the issue of empanelment. And then after that, we'll make a ruling for the way forward. So let us proceed. Let us be courteous to each other. Let us be courteous to the parties before us. Parties before us are very okay, but let's not be a theater by advocates to derail the process. I beg you. On the issue of time allocation, Judge Mureba will give the final issue directions on time.
Okay, this is how we'll proceed. The applicant
It's only one applicant. Only one.
The applicants will have 20 minutes to argue their application. Any party in support of that application will have 5 minutes to support that application. And the respondents will have 7 minutes each to respond to the application, as well as any other party which will want to respond to the application.
We are aware that there could be parties who, for the good reasons given, may not have filed anything. But we also appraise ourselves for the fact that the issue before the court is an issue of law. Therefore, we'll give you time to make submissions on the issue.
May I please? The client, I and my colleagues represent is the subject of the removal of the subject of his pleas petition of the court. The application for the constitutional bench is made in E015 by my friends Mungai, so that effectively the subject matter of removal is being given only 5 minutes. I plead with you, give us 10 minutes.
How long do you need?
10 minutes. I would have said 20.
10 minutes. You have 10.
Thank you.
My Lord, can I be heard? Can I be heard?
Yes.
My Lord, I received the instructions yesterday from K24 Syria. Oh, I'm sorry, I speak loud. I received the instructions yesterday from K24 Syria that I come and make an application that K24 Syria would like to be enjoined to this matter. We all know K24 Syria. We can't pretend that we don't know K24 Syria. And we know the role K24 Syria has played in advancing jurisprudence, constitutionality, and the rule of law in this country. So I urge you respectfully that you place my name on record. Secondly, I would like also to place my name on record in my own right as an elder at the bar and one who has seen quite a number of things which I may not be able to say if I'm representing K24 Syria.
That is okay.
Thank you very much. May I then comment on one small thing, my thoughts? My lords, the country is in a crisis. There's a constitutional crisis. There is a national crisis. And our coming to this court is like commencing or opening an opportunity for healing in the country. And if I may say so with tremendous respect, this is not a matter where it should be allocating some 5 minutes, 10 minutes, 20 minutes. No, that is not suitable. Let these lawyers talk. They are part of the healing process to the 15 million of Kenyans. A number of them are glued now to radios and TVs trying to hear what is being said in this court. And for this honorable court to come and say that my honorable friend, Mr. Mwite, will only have 10 minutes, will have no 5 minutes.
Mr. Mwite asked for 10 minutes and we allowed him to have 10 minutes.
He said so because he was under coercion.
That
is correct.
My lords, may I say, I have taken the trouble to read this constitution of Kenya. I have taken the trouble to read the constitutions of other countries. In fact, the way things stand at the moment, the constitution law is evolving in such a manner that it's no longer confined only to Kenya. We can have a concept of international constitutional law. And if you read that law, including the American law, which I've taken the trouble to read, and which I've had access to it for many years.
Dr. Kavuna, we made proposals and we gave directions. Apparently, you are not satisfied. What is your version? What would you want us? You want to us give everybody how much time?
My lord, forget about the concept of time. Forget, where are we heading for? What are we heading for?
So,
yeah, we want the country to wake up and to revive and to give the life to the country. The country is Kenya, if you don't know what I'm talking about. Your Honor, let the lawyers say what they want to say. This should be part of the healing process of the whole country.
Dr. Kaminga, I ask you.
Yes.
We have given directions on time allocation.
Your hands are not tied with respect.
Okay, tell us, just tell us, in your view, how much time do you want us to allocate parties?
What I'm saying to the tremendous respect to my lord, we talk about time in civil matters and so on. But we are dealing here with the issue of impeachment. Issue of impeachment of the deputy president. It's not a small matter at all. It's a matter that is starting the whole nation. It has paralyzed the nation.
We have heard you, Dr.
And
Kaminga.
let Paul Mwite be given as much time as he wants. Let the professor be given as much time as he wants. Let the Honorable Attorney General be given as much time as he wants. That is the healing process. And from this court, we shall all march forward with confidence. If I may quote Mutajo Makinyata, kifua mbele na matako nyuma. Yeah. Okay. Let us do that. Let us forget about time. Where are we going? Where are we going? Please, I'm speaking. Will you speak? Sit down. With respect, will you sit down, please? Khamino is talking. Will you sit down? It doesn't matter what you call yourself. Would you sit down, please? Yeah. I am talking. I have got the floor.
Under the rules of this court, senior counsel has preference, speaks first before any other person except the Attorney General. So if you would please sit down. I, as senior counsel...
I will not sit down. We're not practicing law. You are still doing breastfeeding.
That is also...
Don't give yourself serious title that you deserve at all. You are doing previous...
Excuse me?
You are doing breastfeeding. Don't give yourself titles which you don't deserve. My Lord, what
Dr.
I'm saying
Kamuna,
to you...
finish what you are saying.
What I'm saying to you, my Lord, we need a healing process, and this court is going to provide that healing process. Let the lawyers say what they want to say. What are we hurrying for? Let us not have some people calling themselves professor or senior counsel, titles that don't mean anything at all when it comes to use.
I think
yes.
they mean something, Dr. Amina. They do mean something.
Something means something when it is you and you approve it. Yeah. My Lord, all that I'm saying to you, let people talk. Let people address you. Where are we going?
People will talk.
When the country is burning.
Dr. Camilo, you have made your point. Please.
Yes, thank you very much.
You have made your point.
I have made the point. Yes.
Professor.
We have a deputy chief justice who has been removed irregularly. Let us be given time to be able to address you. Thank you.
I think those of us who are representing substantive respondents, we all agree that you have given orders that we will comply with, including my learned senior, PK Moite, who I believe you have added some more time and he's happy with that. Maybe it would help if we informed Dr. Kaminwa that it is not the whole matter that is being heard in 10 minutes. It's a very small slice of an application on empowerment. That's all I wanted to clarify.
So, Dr. Kaminwa, I've heard what you said.
Thank you.
We'll stick to the time allocations, but in the event that one party needs more time, they will tell us.
Well, when we come to substantive matters, let people say what they want to say.
I agree with you.
Yeah. Where are we heading to?
Thank you.
Yes. Thank you.
Madam, in view of that time allocation, and I thank Senior Counsel, the senior most going by the Kenya law reports before you, may I...
By the way, mention my name. Mention my name.
Camino.
Thank you.
My Lord, even the report of the East Africa Law Community confirms that. My Lord, the point I need to make, and I beseech you, because of the serious time that we had to prepare this application, I could only prepare for certain aspects of this application. My colleagues, Professor Gada, and my colleagues, Ndegwa and Jiro, within the 20 minutes that you have allocated, I will say my piece. It is insufficient, but I'll try. Please give Ms. Professor Gada and Mr. Ndegwa and Jiro 10 minutes each, and at the end, when we hear what the respondents are saying, you kindly give me, you did indicate, 20 minutes to do a rejoinder. That will enable us to be able to proceed without anybody feeling we want to be here forever. We don't actually want to be here forever. We want to deal with the business of the day. So that does not change any time allocations by more than 30 minutes. So I urge you a lot.
So who's starting?
I'm starting.
Okay.
Yes. So that I do 20 or gather 10, 20, because he has to deal with some authorities. I didn't get enough time. And it's under 10, then I'll do the rejoinder. My Lord, the application that is before you is dated today. It is supported by the affidavit sworn by, it is supported by the affidavit sworn by Honorable David Muni Madenge. And for the record, all lawyers from Matiba, Ogada, Ndegwa, and myself, the record indicates we act for everybody without drawing any distinctions, because there will be no time for that. So we act for all the respondents, all the petitioners, for purposes of E015. My Lord, before going on to argue this application, there is a small point that I wish to make regarding the issue of why are we having a situation where to everybody watching we seems to be following an unusual path. My Lord, there is one substantive issue of procedure that we need to point out. The petitioners are before you on account principally of the violations of the Bill of Rights. the petitioners are also here on account of the relevant provisions of impeachment. The petitioners are before you, my lords, on account of the fact that the business that the framers of the Constitution ordered, one, for appointment of a nominee to take place within 14 days, and for Parliament to do it within 60 days, somehow happened within 4 hours. My lord, those are the principal reasons why we are here. And what is the immediate context? The immediate context, my lords, and why we are here, is that when petitions are filed, the duty of this court under Articles 19 all the way to 25 is to ensure that it decides whether or not the violations as alleged by the petitioners has taken place. My lord, the way in which the law, and this is express positive law, requires that to be done is by way of a judgment. By way of a judgment is the only way that the people of Kenya would be satisfied. Have these rights been violated or not? In order to ensure that that judgment, which is the express constitutional mandate, is given in circumstances that are not academic, Article 23 of the Constitution provides that conservatory orders may be given. When this matter went before your brother judges, probably a sister also, in their wisdom, they directed this matter as such enormity that we need to preserve the subject matter. That subject matter, my lord, the preservation of it would be to ensure the relevant office remains vacant until this case, through a judgment, pronounces itself. But my lord, why are we here and why is there a heated discussion? We are here and we are having a heated discussion because what is the clear intendment of the Constitution is being circumvented, so that to ensure that the subject matter is not preserved. My lord, this would be akin to a situation in which somebody comes and says, I am being evicted and my things are being removed. A court says, stop the eviction process up to where it has occurred. Then the respondent comes and says, no, lift those orders so that I can carry those things that it is alleged I was unlawfully taking. So that, my lord, in the face of the fact that what conservatory orders are supposed to serve, I beseech you, and I believe the entire country would expect that there has to be preservation of the subject matter of the applications. So that, my lord, now, that being the context, it is absolutely important that we do not lose sight of the moment. It is heated, one, because there was a sitting on Saturday. Before application responses could be made, we found ourselves here. We were supposed to come here on Thursday. We are here on Tuesday. So that, my lord, and there are a lot of matters that directions must be given. So that, my lord, that context would be absolutely important because when all is said and done, the critical issue before this court is a right under Article 25, the right to fair hearing and human dignity. Right to fair hearing and human dignity cannot be violated even during an emergency. My lord, that being the background, I ask you, and we shall be asking you, because that is the context where all these things are happening, that you ensure that whether heaven falls, the High Court must stand up, if for nothing else, for the right to preserve the subject matter until this High Court pronounces itself through a judgment. Because that is express law. Having said that, my lord, I come to the prayers. The prayers are like this, and we had already indicated. There are about 6 substantive prayers. The linchpin of these substantive prayers, my lord, is the fact that the Deputy Chief Justice, under Article 165, does not have the power to appoint or assigned as the words used by the constitutions, members of a certain court to hear the matters. My Lords, Article 165.4 is very clear. Where the constitution say the president and Article 149 can nominate Kindiki, there is no argument that is made that a minister or somebody else can be made. We expect that. There can be no feasible argument where the constitution has expressly said that the Chief Justice shall do something. The Chief Justice in this case did not empanel this bench. My Lord, we are urging this honorable court to make a finding that unless the constitution is interpreted or amended to give the Chief Justice, the Deputy Chief Justice, the power to empanel a bench by express reading of the Constitution, she cannot be able to do that. Issue number 2, my lords, is that it is not for nothing that it is one of the biggest occasions that the senior most judicial officer is the one that the people of Kenya, judicial power in the first place, vests in the people. Power by express words of the Constitution or to do this appointment and to act under Article 165 was vested on the Chief Justice. It is not by accident. It is by the express intention. So that, my Lord, on the face of it, when a state officer who is not directly mandated to do something ends up doing it, under public law judicial review, it is done every day. You did not have the power under statute or the Constitution to do that. There are so many cases, starting with Madhwa versus Republic. I think it was sometime in 1974, where somebody at City Council did something where the law did not allow that person to do that. So that, my Lord, all these cases we are aware of. So that, my Lord, as far as Article 165 is concerned, we submit that that is not possible. But, my Lord, this argument is developed a little bit further by the petitioner's applicants. Because the petitioner's applicants are saying that the Deputy Chief Justice, having usurped the powers of the Chief Justice, she proceeded to do two things. One, to sit at night to appoint a bench, and to authorize that bench that sat on Saturday to conduct their business on Saturday. My Lord, those are irregular, because as we are saying, when this is not a matter of public emergency. Of course, it was a matter of public emergency before the National Assembly and before the Senate. But because of the timelines we've given you, my lords, it is not a matter of public emergency. But having found herself in that situation, she decided to treat this matter as one of public emergency. Then, my lord, she directs come and sit on Saturday. We have set out in our applications and in our affidavit. There must be certain circumstances under our laws, the High Court Administration and Organization Act, that can justify for any bench to sit outside on Saturday and Sunday. There must be express reasons. Those express reasons, as we sit here, are aggrieved. We still do not know them. And if we do not know them, every Kenyan who would be aggrieved by a decision made in these circumstances would have every reason to be concerned that from the word go, there was a conspiracy to commit injustice. My Lord, all of you have been honorable members of the High Court. There cannot be, where there is no public emergency, for occasions to arise that for the first time you would effectively be accused. You engaged yourself in a conspiracy to undermine the constitutions and to defeat it in a manner that would amount to treason. So that, my Lord, the point that we make is that in the absence of a public emergency, what has so far happened is not only just unconstitutional, but something that would amount to violation of the Constitution, and something that would amount to violations of the Penal Code, as far as the issue of observing justice is concerned. My Lord, for argument's sake, we proceed to make that argument. Let's assume that there was an emergency. We submit there was none, but let's assume there was one. If there was an emergency, then it was incumbent upon the Chief Justice to read, and they were in the newspaper and in the news, all these cases that honorable judges of the High Court from various stations had recommended for a bench to be appointed to hear them, to consider them, and place them for hearing on Saturday, and to fast-track that hearing. But, my Lord, what is it that happened? My Lord, what actually happened is that you have a situation whereby the respondents, who are basically agents of the government of Kenya and its various appendages, have gotten their applications to be satisfied and for a bench to be specially convened to sit, because from the standpoint of the petitioner, to set aside the conservatory order in order, as the petitioners contend, the violations of the Constitution may be completed. My Lord, justice in this case, if it means anything, it must mean a very simple issue. The multiple violations of the Constitution that are already ingrained and embodied in the various applications, we cannot allow them to be completed, because this is what it's all about. This is what the decisions of the Chief Justice was all about, to complete the serious violations of the Kenyan Constitution. By your oath of office, your lordships are committed to stop a respondent and a government and its appendages that act in this manner. My Lord, what does it amount in law for the Chief Justice to say you have about 15 or 20 cases, as I hear from my learned colleagues who have been in this matter longer than me? I'm here today for this matter, and I'm here because there is a constitution in Kenya. My Lord, that being the case, there has to be satisfaction. If the Chief Justice, and she's a party in this application, cannot be able to justify why did you choose to address the grievances of the Attorney General and the government of Kenya and leave the petitioners the first right of hearing under our Constitution, I deal with Mutunga rules every day, is that the petitioner will have their rights to be heard, to prosecute their case. That is what the Bill of Rights means. The respondent, even under Mutunga rules, will respond and answer the allegations that have been made. But, my Lord, where the Deputy Chief Justice chooses to fast-track the grievances of the alleged violator, common sense has to be affected. My Lord, the conscience of this court must be bothered. Such conduct, in the normal sense of things, we went through the removal of judges during those days. There was just minor infractions of the right to be heard, and judges were shown the door home. But, my Lord, here, it is a systematic decision consciously made that would have very harmful effect for the jurisprudence of our country and for the meaning of our Constitution. So that, my Lord, so that my learned friends can be able to speak for themselves, we are alleging that as long as the bench has been appointed by the Chief Justice, who has declined to follow the fair process for purposes of appointment of the various judges to sit, there cannot be a valid appointment. Not because I and my colleagues here would have anything on a good day before any of you, your lordships. We have done very many matters. You have courageously stand up for the constitutions in various matters. But, my Lord, unhappily, we have to be the ones saying that it would appear to a section half of this country, if not 3/4, that you have been enlisted in service of the violations of the constitutions. My Lord, that may not have happened, but that is the only way reasonable people would be able to interpret all this, particularly against the background that even the Gen Z were abducted. The substantive Chief Justice did not empanel a single bench to sit on Saturday or on Sunday. That is why but the context in which this matter must be viewed. My Lord, there are certain authorities. My learned colleagues will go through them. But I need to mention at least two things. My Lord, of course, the arguments would be made. I think there was some time back, probably in the Okiya Omtata case, my learned colleague will clarify, where the Deputy Chief Justice, the same Deputy Chief Justice, made an appointment. There was no substantive Chief Justice at that time. There was a decision that was saying, this is administrative. That decision is not binding. But, my Lord, more importantly, now that this issue is arising directly, this court must retire, make a very reasoned decisions to settle this issue. Whether in every other case in which the Constitution or statute says so and so will do this, if that so and so does not do it without failure, the High Courts and the Court of Appeal have always held there was no jurisdiction. An order of certiorari have always issued. It shouldn't be different in this particular matter because the power belongs to the Chief Justice. My Lord, the second issue is a decisions, I believe, one of you was involved, and which is that case? I believe it is a case of K24 versus JSC, and the decision in that decision was that at paragraph 29 to 38, basically it says that where there is a substantive Chief Justice who is a state officer, she does not cease to be a Chief Justice in this era of technology. And accordingly, the Chief Justice, the CJ, does not have authority under the constitutions to assign roles assigned to that office. So that, my Lord, in this case, even assuming that in writing the Chief Justice had assigned this role to the deputy, and that has not been alleged, it would still not be good enough, because wherever that the good Chief Justice might be, this is something that she could have done as expected her. And the people of Kenya obviously would be interested because of the nature of this matter. Why would the Chief Justice abdicate to do her job and let her deputy to do her job in a manner that aggrieves the petitioners? That is an important question, because it is the job of the Chief Justice. There is a huge mandate that is given by the Chief Justice. Do your job with the entire authority that your office carries. So it cannot just be that it is for the Deputy Chief Justice who has usurped. It is also abdication. What would be the basis for abdication? The Chief Justice not to do their job. The other case of, just 1 minute, 1 second. The other case of, I think my learned colleagues, so that it can be fast, I don't want people to knock me. My learned friend can do her. Let him do his 10 minutes, then he can do his 10 minutes.
Thank you. Thank you very kindly, my lords, my lady. I'll only highlight a few issues which are legal. I'll move from Article 1 of the Constitution, your lordships. That Article 1 has created organs of government. Among them is the organ of the judiciary. It has clearly provided, your lordship, that the people of Kenya, in exercise of their sovereignty, they have delegated their powers to those organs. In this case, the power under Article 165, Clause 4, is exclusively delegated to the Chief Justice. Your lordship, in administrative law, it's right that a person who enjoys delegated powers cannot further delegate those particular powers. In this case, in this circumstance, your lordship, it is not known to the petitioners under what circumstances the Chief Justice may have delegated these powers to the Deputy Chief Justice. It is our humble submission, your lordship, that the powers and the functions under Article 1 are not capable of being delegated. Further to that, Your Lordship, you seek leave under Article 159 of the Constitution, which provides that, Your Lordship, that judicial power is derived from the people and shall be exercised by the courts and tribunals established by this Constitution for and on behalf of the people. That article, again, clearly indicates that this power under Article 165, Clause 4 is not capable of being delegated. How about, Your Lordship? In the Constitution, Your Lordship, I invite you to look at Article 260 of the Constitution. It provides if a function has been created to be executed by a particular organ, it is only that organ that is capable of executing that particular function. And for the question of further delegating that particular function cannot arise so as to say that the Deputy Chief Justice had the constitutional mandate to appoint this bench to adjudicate over these particular files. Your Lordship, we have put up a case that the Deputy Chief Justice has not only violated the Constitution, but also violated the rights of the petitioners to be heard under Article 50 of the Constitution. When they move to appoint a bench of this, the bench, and fail to notify the parties herein as evidenced by the counsel appearing for the petitioner in petition number 14, it tells Your Lordship that the expediency for which it was done was so as to meet the objective of setting aside the orders that were granted by your brother Justice Mwongo and your brother Justice Mwita. Your Lordship, when you retire to make a ruling of our application, it is important that you pay serious attention to paragraph 12 of our affidavit, paragraph 21 again of the affidavit, paragraph 22 again, and also paragraph 27. And then you might want to ask yourself, under section 10 of the High Court Organizations, High Court Administration Organization Act, how, under what circumstances did the Chief Justice, the Deputy Chief Justice, authorize you to sit on a Saturday? Under what circumstances did the Chief Justice herself, Deputy Chief Justice herself, sit at night, in the wee hours of the night, ungodly hours, and constituted this bench? Your Lordship, it's our humble submissions that Article 10 has only arrogated that function again exclusively to the Chief Justice, and that the Deputy Chief Justice has no power under Section 10 of the High Court Organization and Administration Act to order you or to authorize you to sit on an odd day like that or the Saturday. Your Lordship, permit me to draw your attention again to the case of Omtata. When you retire and the judgment will be highlighted by my learned friend, it is of importance, Your Lordship, that you look at paragraph 192 of that judgment. It has given the circumstances under which the Deputy Chief Justice can act in the absence of the Chief Justice. One is if the Chief Justice is indisposed, if he resigns, if he is dead, or if he is voted out of office. The question of leave, to which we are submitting without knowledge whether that is the circumstance that led to the allocation of powers by the Chief Justice, is not one of the grounds or reasons that the Chief Justice can exercise, the Deputy Chief Justice can exercise the exclusive powers meant for the Chief Justice. Finally, Your Lordship, all these averments contained in our affidavit have not been controverted by the respondents through a replying affidavit. They have only filed the grounds of opposition, to which they shall bring to your attention the case of Conchela, which has been distinguished by the case of Okia Omtata. The grounds contained in our affidavit, Your Lordship, are uncontroverted and they must be admitted as such. I beg to rest my case.
Specific reference to Okio Montaka probably the most prolific litigator in the history of Kenya, so we don't know which of many cases are you referring to.
I will certainly be addressing my senior at the bar and senior at the academy, Professor Gideon Muigai. It's always a pleasure being with him in court. A man or woman who plants a tree, not knowing fully well that they will not sit in its shade, knows the meaning of life. You sit today in such an epochal moment that what you do here has significant ramifications for the Republic of Kenya. It is for you and the court to rise to the occasion. This court has defined the Constitution as a transformative constitution. And this was done by this very court, differently seated in the BBI case, David Ndii and others, versus the Attorney General. And this is what the court said about the Constitution 2010. It is a constitution of a transformative character. And this transformative character of the Constitution induces large-scale social change, including the character and conduct of politics. That the Constitution bears an internal theory of interpretation. The starting point for discerning that internal theory is Article 259 of the Constitution. That formalistic approaches to constitutional interpretation are not favored. And lastly, that the Constitution has provided for its own theory to protect its values, objects, and purposes. That is what is before you as a court today, that you are supposed to maintain that innate character of this Constitution as a transformative charter. The other side has filed grounds of opposition, and in their grounds of opposition they raise a case, Lorna Conchela and others versus the Chief Justice. That was the grounds of opposition by the Attorney General. And in that case, this High Court said that the power to appoint a bench is administrative, and that that power can be performed by the Deputy Chief Justice in limited, constricted circumstances. That the normative holder, the Chief Justice, performs it, but the Deputy Chief Justice has to perform it in certain limited circumstances. Those limited circumstances have to be demonstrable. That is Conchela. Your Lordship Justice Murima, sitting in Okoiti versus JSC and another petition, E408-2020, 2021 EKLR, I believe that is what Professor Gideon Muigai was asking about. Paragraph 29 to 38. Justice Murima finds that the authority under Article 165.4 is a constitutional authority, so that that authority cannot be delegated by the Chief Justice, because the Chief Justice does not cease to be a state officer, even on leave. We have another authority here, Petition 31 of 2013, Kenya Medical Research Institute versus the Attorney General. This is found at 2014 EKLR at paragraph 37. Kenya Medical Research Institute versus the Attorney General and three others, 2014 EKLR. This case at paragraph 37 says this, that the Chief Justice and the